Good afternoon. I didn't expect to be saying good afternoon, but good afternoon. I hereby call to order this third meeting of the Pennsylvania Public Utility Commission for the year 2017 and ask that you please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. The first matter for today's agenda is the approval of the minutes for the meeting of January 19th, 2017, and I will call on Commissioner Coleman, who is the editor of the minutes.
Well, thank you, Madam Chairman. I've reviewed the minutes of the January 19, 2017 public meeting and move that they be approved as submitted.
You have heard the motion of Commissioner Coleman to approve the minutes as submitted. Is there a second?
Second.
Second by Commissioner Sweet. Any discussion, any edits? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. Now call on our Director of the Office of Special Assistance, Cheryl Walker-Davis, to lead us through today's agenda.
Good morning, Madam Chairman. Good morning, Commissioners.
Good afternoon.
Good afternoon. Pavlov's dogs. May it please this honorable commission, on behalf of your various offices and bureaus, we present for consideration and disposition the following agenda items, commencing this morning with matters on behalf of the Bureau of Audits on page 1 of the public meeting agenda. It is recommended that the commission adopt that bureau's recommendation to release the audit report involving the PPL Electric Utilities Corporation's Universal Service Rider for the two 12-month periods ending 11/30/14 and 11/30/13.
Is there a motion to adopt the staff recommendation?
So moved.
I heard Vice Chairman Place, a second by Commissioner Pellison. Under discussion, any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning now, it should be noted that on behalf of the Bureau of Consumer Services on page 2 of the public meeting agenda, the matter there appearing pertaining to the Duquesne Light Company's Universal Service and Energy Conservation Plan has been postponed until public meeting of March the 2nd. Turning now to matters on behalf of the Office of Special Assistance, commencing on page 3. It is recommended that the commission adopt the recommendation in the proceeding involving the complaint of Sandra Benedict versus Columbia Gas of Pennsylvania, Inc.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Sweet. Under discussion, any discussion? I would like to make a comment under discussion and say, in reviewing this case, the first thing that came to mind to me is that I truly believe that our utilities do a great job in terms of educating the consumers. But one thing I would like to say to Columbia Gas is to take an additional look in terms of consumer education efforts with regard to the bill multipliers. I think it would help consumers have a better understanding, and that was one of the concerns that I had with this case. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
It is recommended that the commission adopt the Office of Special Assistance recommendation involving the application of Go Green Taxi LLC.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Powelson, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye. Aye.
Any opposed? The motion passes 5-0.
Continuing to page 4 of the public meeting agenda, and the first matter on the top, that being the proceeding involving the formal complaint of Paul Copanicia versus Pico Energy Company. There is the motion of Commissioner Coleman.
Is there a motion to bring this matter up for consideration?
So moved.
Is there a second?
Second.
Motion by Commissioner Powelson, second by Commissioner Sweet. Under discussion, I would recognize Commissioner Coleman for his motion.
Thank you, Chairman. I'd ask that my motion be entered in the record as I read it in its entirety. Before the commission are exceptions and reply exceptions to the initial decision of Administrative Law Judge Darlene Hepp on June 9, 2016, dismissing the above captioned formal complaint for failure to prosecute and meet the burden of proof. The complainant alleged that PECO Energy Company had threatened to terminate service over an unpaid balance and required a payment arrangement, as well as a review of the amount of arrearages, eligibility for medical certifications, and a review of the prior complaint, which had not been adjudicated. An in-person evidentiary hearing was scheduled for this matter on March 31st, 2016. The complaint was sent the standard hearing notice with the date, time, and location of the hearing. The notice also informed that the case would be dismissed if the complaint did not appear at the scheduled hearing, and that any request for change of hearing date must be submitted 5 days in advance of the hearing date. On March 30th, 2016, the complainant served PECO with a letter addressed to the Commission Secretary requesting permission to withdraw the complaint. The complaint also mentioned that it would not object to mediation. On the same day, PECO replied in writing to the ALJ that objected to the withdrawal of the complaint and declined to participate in mediation. On March 31st, 2016, PECO appeared at the evidentiary hearing, but the complainant did not. PECO moved to have the case dismissed with prejudice for failure to prosecute and meet the burden of proof, which the ALJ granted. In his exceptions, the complainant maintained that he had withdrawn the complaint and he was awaiting a decision on the request for mediation. In reviewing this matter, I'm guided by the Commission's precedent involving the reversal or modification of initial decisions where a complaint has been dismissed with prejudice for failure to appear at evidentiary hearings. The Commission has, on rare occasions, reversed or otherwise modified these initial decisions where the record showed that the complainant made a good faith effort to participate in the evidentiary hearing. The Commission has also permitted the withdrawal of applications instead of denials where the applicant had properly filed the withdrawal with the Secretary and there was no sign of abuse of the Commission's process. However, none of these precedents are applicable in this case. There's no evidence that the complainant made a good faith effort to attend a hearing or alleged any other unique circumstances to warrant his absence. In fact, the complainant was well aware of the date of the hearing as evidenced by the request to withdraw the complaint the day before it was to take place. Furthermore, a request to withdraw a complaint and/or to mediate a complaint does not automatically stay the scheduled hearing. The proper procedure to change a hearing date is to request a continuance in writing no later than 5 business days prior to the hearing. No such request was made by the complainant in this case. By not attending the hearing, the complainant took the risk that his complaint would be dismissed, as explained in the pre-hearing notice and pre-hearing order. Accordingly, I move that the exceptions be denied and the initial decision be affirmed in its entirety. Therefore, I move that the initial decision of the Administrative Law Judge Darlene Hepp be affirmed and the Office of Special Assistants prepare an opinion in order consistent with this motion.
You've heard the motion of Commissioner Coleman. Is there a second?
Second.
Second by Commissioner Sweet. Any discussion on the motion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0 on the case as amended by the motion. If there's no objection, we'll take the previous roll call. Seeing none, the matter passes 5-0.
It is recommended that the Commission adopt the staff recommendation in the next 2 matters pertaining to motions for default judgment of the Bureau of Investigation and Enforcement versus Sean Cab, Inc., TA Delaware County Cab Company, as well as the a motion for default judgment involving the Bureau of Investigation and Enforcement versus Ronald Cab, Inc.
Is there a motion to adopt staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Powelson, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning now to page 6 of the public meeting agenda and matters presented on behalf of the Bureau of Technical Utility Services, it is recommended that the Commission adopt that Bureau's recommendations in the first 3 items on page 6, concluding with the recommendation in the proceeding involving the application of LSC Communications US LLC to provide service as an electric generation supplier.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Powelson. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
At the bottom of page 6, with regard to the last item, it is recommended that the Commission adopt the Bureau's recommendation involving the petition of People's TWP LLC for approval of its second long-term infrastructure improvement plan, noting the statement of Vice Chairman Place.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Powson. Under discussion, I would recognize Vice Chairman Place for his statement.
Thank you. Madam Secretary, I wish to have my statement placed into the record as if I had read it in its entirety. Before the Commission for consideration is the petition for approval of the revised second long-term infrastructure improvement plan of Peoples TWP filed on August 22, 2016. The Commission directed TWP to file a new second LTIP to span at the minimum from 2017 through 2021. TWP's current LTIP spans the calendar years 2013 through 2017 and was approved in May of 2013. TWP's historical at-risk pipe replacement rate was approximately 17 miles per year. This replacement rate was augmented by TWP's original LTIP replacement rate of 27.4 miles per year for the period 2013 through 2017. This revised LTIP results in a lower replacement rate of 22.4 miles per year for the period 2017 through 2021. This reduction is caused by a new focus on replacement of more risky urban area mains, which are more by nature more costly to remove. According to TWP, within their system there are approximately currently 762 miles of unprotected bare steel pipe. Therefore, the company has 16 years to remove this pipe if it is to achieve its 20-year at-risk main replacement goal. This averages out to 47.6 miles of main replacement per year, more than twice the projected main replacement rate of 22.4 miles under the revised LTIP. In recognizing this necessity for substantive acceleration in the out years, the Commission is reiterating its directive from its July 2016 order that TWP is to maintain its 20-year objective despite the additional work required to replace all at-risk customer-owned service lines. To ensure that this is the case, our order directs TWP to file a document with the Commission detailing the projected spending levels and mileage of target pipe to be replaced through the final year of the 20-year plan in 2032. This document will include a detailed construction division plan as well. I strongly support this directive to ensure that TWP does remove the at-risk pipe within the 20-year plan. This directive should help the company to develop its planning requirements to achieve its commitment to ensure safe and reliable service. Thank you.
Thank you, Vice Chairman Place. Any further discussion? Hearing none. All those in favor say aye. Aye. Any opposed? The motion passes 5-0.
In omnibus fashion, it is recommended that the Commission adopt all of the recommendations appearing on pages 7 and 8 through the last item appearing at the bottom of page 8 in the proceeding involving the Aqua Pennsylvania, Inc., White Horse Meadows application for approval to provide service.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Powson, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
On page 9, continuing, it is recommended that the Commission adopt the recommendation in the matter involving the UGI Penn Natural Gas Company general rate increase request, noting the statement of Vice Chairman Place.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Powson, second by Commissioner Coleman. Under discussion, I would recognize Vice Chairman Place for his statement.
Thank you. Before for consideration, as noted, is the UGI Penn Natural Gas's filed tariff to become effective March 20th, 2017, seeking a general rate increase calculated to produce $21.7 million in additional annual revenues. Because this filing has been protested, the Commission will suspend and investigate the company's proposed tariff filing and the supporting data, including the reasonableness of the respondents' existing rates, rules, and regulations. In furtherance of this investigation, I have asked the parties to address certain directed questions as part of this base rate case proceeding. I wish to have those questions placed into the record as though I had read them in their entirety. I encourage all parties to provide information that will assist the commission in reviewing and analyzing this rate proceeding. Thank you.
Thank you, Vice Chairman Place. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
It is recommended that the commission adopt the recommendations commencing with that involving the application of Aqua Pennsylvania, Inc., pertaining to the provisioning of service to a resident on White Horse Road in Charleston Township, Chester County, Pennsylvania, and continuing with remaining items on pages 9 through and including this item on the top of page 10 in the matter involving York Water Company.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Powelson. I did hear a slight second over there at the end.
With enthusiasm.
Okay. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
In consideration of the next item involving the application of Lyft, Inc. for a license to provide transportation network company services, we recommend the adoption of the staff recommendation in that item, as well as the recommendation of staff in the matter appearing on page 11 entitled Freeman Autonomous Vehicles LLC, noting the joint statement that you have, Madam Chairman, along with Commissioner Powelson, involving each of those proceedings.
Is there a motion to adopt staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Powelson. Under discussion, I would recognize Commissioner Powelson for the joint statement.
Thank you, Madam Chair. I'd like to have our joint statement entered into the record as if read in its entirety. It's consistent with a prior reading of the Uber statement after their license approval. Again, this represents another milestone accomplishment for this commission with the adoption of Act 164, which now provides permanent licensings to transportation network companies here in the Commonwealth of Pennsylvania. As we all know, TNCs provide the traveling public with safe, reliable, affordable, and user-friendly transportation options. And I think that's been demonstrated by a number of consumers here in Pennsylvania who have used these services. We've also seen empirical data on reductions in things like DUIs in major urban areas of the Commonwealth. I also want to note that TNCs are good for the transportation industry, as we've experienced firsthand with electric restructuring competition here in the marketplace. That competition is beneficial because it gives consumers the power of choice and the ability to shop with a number of different provider options. As evidenced by the number of riders who have flocked to use TNCs in areas of the Commonwealth, this is exactly what we had expected in approving these licenses. I make another point that TNCs are investing in Pennsylvania. As we see in the great city of Pittsburgh, a new venture taking place around autonomous vehicles. And the fact that this can be done, as I mentioned earlier, in any jurisdiction across this nation, that Pittsburgh was one of the selected areas for this pilot. So in recognition of this, we'd like to again commend the General Assembly for passing Act 164 and paving the way for innovative transportation services to thrive here in the Commonwealth of Pennsylvania. As we said from the beginning, the Commission has supported the passage of TNC legislation because of all the benefits the service provides customers. Today, we are pleased to add 2 more companies to provide them licensing here today by Act 164 to become permanent TNC operators here in the Commonwealth of Pennsylvania. And Madam Chairman, as we continue to do these joint statements together, I think this might be an ongoing opportunity that we'll see more TNCs popping up across the Commonwealth of Pennsylvania.
I agree. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
It is recommended that the commission adopt the staff recommendations in the remaining matters pertaining to the Duquesne Light Company letter of notification for approval to reconductor a segment of an existing transmission line in Allegheny County, the recommendation pertaining to electric generation supplier license cancellations, and on page 11, the recommendation pertaining to the filing of a security certificate and affiliated interest agreement of the Peoples Natural Gas Company, LLC.
Is there a motion to adopt the staff recommendations?
So moved.
Second.
Motion by Commissioner Coleman, second by Commissioner Sweet. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning now to the presentation of matters on behalf of the Law Bureau, appearing on page 12 of the public meeting agenda, with regard to the first item pertaining to the United Telephone Company of Pennsylvania, LLC, DBA CenturyLink, and Dex Media, Inc., joint petition to reduce the distribution of paper telephone directories and transition to digital publications. There is the motion of Commissioner Coleman.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Powelson. Under discussion, I would recognize Commissioner Coleman for his motion.
Thank you, Madam Chairman. I'd ask that my motion be entered into the record as though I had read it in its entirety. CenturyLink and Dex Media, Inc., the publisher of CenturyLink's phone book, has petitioned the Commission to reduce the provisioning of printed telephone directories in CenturyLink's service territory in Pennsylvania. Upon review of the pleadings in this case, I believe there is some ambiguity with the scope of the requested relief. On one hand, the joint petition appears to request Commission approval to end saturation delivery, i.e. delivery to all households within the market, of printed directories of all forms, whether residential or business listings of both white and yellow pages. On the other hand, the requested relief could be viewed as being limited to business white and yellow pages only. Because of this ambiguity, I am reluctant to grant either form of relief. Therefore, I propose to grant the same relief that was previously granted to Verizon PA and Verizon North under a prior Verizon directory order. Relief from saturation delivery of the residential white pages only. Granting this relief is consistent with the Commission's precedent and recognizes the well-documented changing telecommunications landscape and the digital alternatives identified in the record that exist for customers to obtain directories information at no charge. At the same time, we need to be mindful that those customers who have limited or no access to or no desire to use electronic alternatives to obtain directory information. Therefore, I support the position of the Office of Consumer Advocate that CenturyLink should not be permitted to stop honoring customer requests for printed directories after a certain amount of time or once the certain threshold is reached. Rather, I believe the discontinued paper directory should be available at no charge upon customer request for the terms and conditions as set forth in the Verizon directory order. Therefore, I move that the joint petition of CenturyLink and Dex Media be granted in part and denied in part, consistent with this motion and consistent with the relief provided to Verizon in the Verizon directory order, and that the Law Bureau prepare an order consistent with this motion.
You've heard the motion of Commissioner Coleman. Is there a second?
Second.
Second by Commissioner Powelson. Any discussion on the motion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0 on the matter as amended by the motion. If there's no objection, we'll take the previous roll call. No objection heard, so the motion passes 5-0.
It is recommended that the Commission adopt the Law Bureau's recommendation with regard to the AT&T Corp. And Teleport Communications of America, LLC, petition for an extension of a waiver of the Commission's regulations relating to the tariffing and classification of certain competitive local exchange company services.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Vice Chairman Place. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning now to the matters presented on behalf of the Commission's Office of Administrative Law Judge. With regard to ALJ Salapa's initial decision in the proceeding involving the complaint of Kamikia Mayo versus Philadelphia Gas Works, there is a motion that you have, Madam Chairman, which is a joint motion with Vice Chairman Place, as well as the joint statement of Commissioners Powelson and Coleman.
Is there a motion, do I have a motion to call up this matter for consideration?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Powelson. I would turn it over to Vice Chairman Place to preside.
Thank you, Chairman. I'd like to recognize Chairman Brown for the purposes of the joint motion.
Thank you. I will read the motion in its entirety. This case involves a decision that dismisses a formal complaint filed by a consumer concerning the financial liability for an arrearage that arose, at least in part, before the 3-year period set forth in Section 3314 of the Public Utility Code. By formal complaint filed on August 12, 2016, Ms. Mayo challenged charges for services rendered by PGW when she was a minor or when she was under the care of the Department of Human Services. Because the complaint was dismissed on preliminary objections as being brought outside of the statute of limitations, facts which we believe are necessary to make a conclusive determination on this matter have not been entered into the record. While the ALJ read the complaint to say that Ms. Mayo was seeking relief from the amount that accrued in 2004, which was clearly beyond the statute of limitations for commission consideration, our reading is broader. The complaint also appears to be a request for a payment arrangement for arrears which may or may not be subject to the 3-year statute of limitations. Without an evidentiary hearing, we are unable to ascertain if any amount is eligible for a payment arrangement. Therefore, we move that 1, the proceeding be remanded to the Office of Administrative Law Judge for further proceedings on this matter, and 2, the Office of Special Assistants prepare an opinion and order consistent with this motion.
Thank you, Chairman. Is there a second to the motion?
Second.
Thank you. Seconded by Commissioner Sweet. Under discussion, I'd like to recognize Commissioner Coleman for his statement.
Thank you, Vice Chairman. I'd ask that our joint statement be entered into the record as though I read it in its entirety. We agree with the initial decision to sustain the preliminary objection of Philadelphia Gas Works and dismiss the formal complaint as time barred by our statute of limitations and outside our jurisdiction. The proposed joint motion would remand this proceeding to the Office of the Administrative Law Judge based on the view that the complainant appears to be requesting a payment arrangement for arrears, which may or may not be subject to a 3-year statute of limitations. However, even under the most liberal construction, the complaint does not request a payment arrangement. Rather, in accordance with paragraphs 4 and 5, the complaint seeks removal of the PGW charge incurred from 2004 and 2006. Although the Commission often makes certain allowances for pro se complainants, we should not be in the business of using possible claims that may exist but were not raised in the complainant to circumvent the valid statute of limitation defense. We are concerned that such a practice has the potential of seriously undermining what is lawful defense to formal complaints filed at the Commission. This proceeding involves charges that appear to have been incurred by the complainant when she was an emancipated minor. Although we are sympathetic to the complainant's circumstances, the complainant's status as an emancipated minor does not toll the 3-year statute of limitations applicable to her complaint. Lastly, the complainant is not without recourse if we uphold the dismissal of her complaint. If need be, the complainant is free to file another formal complaint with the Commission requesting a payment arrangement in accordance with Chapter 14 of the Code. For these reasons, we agree with the initial decision to dismiss the complaint in its entirety and do not support the joint motion to remand the complaint for further proceedings. Thank you, Vice Chairman.
Thank you, Commissioner. Any further discussion? Seeing none, all those in favor of accepting the initial decision as modified by the motion, please signify by saying aye.
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 Any opposed?
No.
No.
The motion carries 3-2. Chairman, the gavel is yours.
Thank you. Now on the matter as amended by the motion. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed?
Opposed.
Opposed.
The motion passes 3-0, noting the dissent of Commissioner Coleman and Commissioner Powson.
Madam Chairman and Commissioners, with that concluding the presentation of regular agenda items, we now turn to the carry-in agenda. It is recommended that the Commission adopt the Office of Special Assistance recommendation in the matter involving the petition for interlocutory review in the proceeding of Center Park Historic District, Inc. and the City of Reading versus UGI Utilities, Inc.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place and second by Commissioner Powson. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
And it is recommended that the Commission adopt the Office of Special Assistance recommendation with regard to the petition for reconsideration involving the Commission's order in the consolidated general rate increase proceeding of the First Energy companies.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Powson, second by Commissioner Sweet. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
It should be noted that under the subheading of Commissioners, the matter there appearing pertaining to the energy affordability for low-income customers, Vice Chairman Place motion has been postponed until public meeting of March the 2nd. Madam Chairman, I believe that that concludes the presentation of public meeting agenda items.
Thank you. Any other matters to come before the commission at this time? Hearing none. Without objection, the meeting is adjourned.